Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, High-Yield Business Association's core rules. Let's begin. The highest yield business associations issues are fiduciary duties, limited liability, and who may sue for entity injuries. California essays often present a closely held business where formalities are loose. Owners treat entity assets as personal assets, and one insider diverts an opportunity. Your answer should distinguish the entity's rights from the owner's rights and the outsider's rights. Business associations is a rules plus policy subject. Explain that limited liability encourages investment, but courts may disregard the entity form when equity requires. Explain that managers need discretion, but fiduciary duties prevent self-dealing. Explain that derivative suits protect the entity when managers refuse to sue, but procedural barriers prevent strike suits. Fiduciary duties in partnerships. Under California partnership law, partners owe the partnership and the other partners duties of loyalty and care, plus an obligation of good faith and fair dealing. The duty of loyalty includes accounting for property, profits, or benefits derived from partnership business or use of partnership property, refraining from dealing with the partnership as or on behalf of an adverse party, and refraining from competing with the partnership before dissolution. The duty of care generally prohibits grossly negligent or reckless conduct, intentional misconduct, or knowing violation of law. Corporate fiduciary duties. Directors and officers owe duties of care and loyalty to the corporation and shareholders. The duty of care requires informed, good faith decision-making with reasonable inquiry. The business judgment rule presumes directors acted on an informed basis, in good faith, and in the corporation's best interests. The duty of loyalty requires directors and officers to put the corporation's interests ahead of personal interests. LLC fiduciary duties. In a member-managed California LLC, members owe fiduciary duties similar to partners. In a manager-managed LLC, managers owe duties, and non-managing members generally do not owe management duties merely as members. The operating agreement may shape duties, but cannot eliminate core statutory obligations in a way California law forbids. Interested director transaction. Identify a transaction between the corporation and a director, officer, controlling shareholder, or related entity. Determine whether the material facts and interest were disclosed. Analyze approval by disinterested directors or shareholders, if any. Even with approval, discuss whether the transaction was just and reasonable to the corporation where required. Remedy may include damages, rescission, disgorgement, or constructive trust. Corporate opportunity. The opportunity is in the corporation's line of business, developed through corporate resources, or of practical advantage to the corporation. The corporation has an interest or expectancy in it. The fiduciary takes it for personal gain without first offering it to the corporation. Defenses include corporate rejection after disclosure or inability to pursue, but inability is not a magic defense if caused by the fiduciary. Piercing the veil. California generally requires unity of interest and ownership such that separate personalities no longer exist, and an inequitable result if the acts are treated as those of the entity alone. Factors include commingling funds, undercapitalization, disregard of formalities, identical ownership, use as a shell, diversion of assets, and misleading creditors. Piercing is more likely in tort than contract, and more likely for active misuse than ordinary business failure. Derivative suit. Plaintiff must have standing, usually ownership at the time of the challenge transaction and throughout the litigation. Plaintiff must fairly and adequately represent the entity's interests. Demand on the board is required unless excused as futile under the applicable standard. Recovery belongs to the entity, not directly to the plaintiff, though attorney fees may be awarded when the suit confers a substantial benefit. Direct injury versus entity injury. If all owners are harmed only because the entity lost value, the claim is derivative. If the plaintiff lost a personal right, such as voting, inspection, contractual buyout rights, or a unique misrepresentation inducing purchase or sale, it may be direct. Closely held corporation versus partnership. Courts may be flexible in closely held entities, but do not ignore entity form without analysis. A shareholder in a closely held corporation does not automatically become a partner. Use corporate rules unless facts show partnership formation or alter ego. Care claim versus loyalty claim. A bad business decision, without conflict or bad faith, usually fails under the business judgment rule. A conflict transaction, secret profit, usurpation, or competition is a loyalty issue and requires cleansing, fairness, or disgorgement analysis. Dissociation versus dissolution. Dissociation is a partner's exit from the partnership relationship. Dissolution begins winding up the partnership business. Do not assume every partner departure ends the business. Modern statutes often allow buyout and continuation. Piercing the veil is not a cause of action by itself. It is a theory to impose liability for an underlying obligation. Undercapitalization alone is rarely enough. Combine it with misuse, commingling, or inequitable conduct. A controlling shareholder may owe fiduciary duties when using control to benefit itself at minority shareholders' expense. Ratification of an interested transaction requires disclosure of material facts. A vague approval is weak. A derivative plaintiff does not personally recover the corporation's lost profits. Partners may bind a partnership even if an internal agreement restricts authority, unless the third party knows of the restriction. When facts show an insider taking a lease, client, invention, or purchase opportunity, write a loyalty analysis before a care analysis. The best answer states, the insider owed a fiduciary duty. The opportunity was related to the entity's business. The insider learned of it through the entity or used entity resources. The insider failed to disclose and obtain approval. Therefore, the entity can seek disgorgement, constructive trust, or damages. When facts show unpaid creditors, analyze entity liability first. If the contract was signed by an authorized agent of a corporation or LLC, the entity is liable. Then analyze personal liability. Shareholders or members are not liable solely by status. Consider personal guarantees, direct tort participation, promoter liability, partner status, and veil piercing. If veil piercing is argued, use California's unity of interest plus inequitable result framework and apply multiple factors. When facts show a shareholder suit, classify claims. Mismanagement, waste, overpayment, and diversion of assets are derivative. Denial of inspection rights, dilution targeted at a minority holder, or breach of a shareholder agreement may be direct. Then discuss demand, futility, standing, adequate representation, and recovery to the entity. A strong California answer is organized by entity and claimant, uses statutory labels without oversighting, and gives remedies. Business associations' essays are rarely about memorizing every filing requirement. They are about applying authority, limited liability, fiduciary obligations, and litigation posture to messy facts. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.